Bankruptcy 101, a lesson for the small business owner. My name is Amanda Brown, and later in this video you'll be hearing from Clay Dixon and Julie Morrison. We will be discussing what bankruptcy is, the different types of bankruptcies, what bankruptcies affect small business owners, as well as alternative options and pros and cons for filing bankruptcy. First off, what is bankruptcy? Bankruptcy is an option that should be considered when an individual or business can no longer meet their financial obligations. Bankruptcy laws were enacted so people who can no longer pay their debts essentially have a way to start over. This is accomplished by liquidating their assets to pay off their debt or by creating a payment plan for their creditors. When you file bankruptcy, a trustee is assigned to your case. A trustee is someone who is appointed by the court and helps to work with your creditors. They work for the government and are typically lawyers or accountants. It is important to remember that your bankruptcy trustee does not work for you. His role in the case is to get as much money back for your creditors as possible. Next, we have jurisdiction. Jurisdiction is the court's ability to listen and decide on a case. If a court does not have jurisdiction over a case, the decision on the case is void. Under the Bankruptcy Code, the federal courts have exclusive jurisdiction over all bankruptcy cases. This means that bankruptcy cases must be filed in our federal court system instead of your state court system. Once a case is filed, the court has exclusive jurisdiction over the property of the individual or business filing the bankruptcy. So now we want to discuss the different types of bankruptcies. There are 6 main types of bankruptcies, and they are Chapter 7, known as liquidation bankruptcy, Chapter 9, municipality bankruptcy, Chapter 11, reorganization, Chapter 12, family farmer or fisherman bankruptcy, Chapter 13, individual debt adjustment, Chapter 15, ancillary and other cross-border cases. Of these 6, 4 of them pertain to businesses. As a business, you're eligible to file for Chapter 7, Chapter 11, Chapter 12, and Chapter 13. Whichever you choose to file is dependent upon how your business is structured and what you plan to do with your business. Now I'll let Julie discuss the different types of bankruptcies.
Thanks, Amanda. Today I'm going to talk about Chapter 7, 11, and 12 bankruptcy. Chapter 7 is the most common form of bankruptcy and deals with liquidation. Any individual or business can file under Chapter 7, whether they are solvent or insolvent. The purpose of Chapter 7 is to take the person's assets and liquidate them, using the proceeds to pay off their creditors. Under Chapter 7, the debtors are allowed to choose between their state and federal exemptions. These exemptions are in place to give the debtor the ability to continue a productive life after bankruptcy. An example of exempt property could be the debtor's home. To file under Chapter 7, the debtor must, along with the petition, submit a schedule of assets and liabilities, schedule of current income and expenditures, a statement of financial affairs, and a schedule of executor contracts and unexpired leases. If the debtor is an individual with mainly consumer debt, they must also submit a certificate of counseling, copy of any debt repayment plans created in counseling, proof of payment if received within 60 days before filing, and a statement of monthly net income. Unlike Chapter 7, Chapter 11 deals with the reorganization of debt. A Chapter 11 petition can be filed voluntarily by the debtor or involuntarily by the creditor. A voluntary petition includes standard information about the debtor: their name, social security number, residence, location of principal assets, their plan or intent to file a plan, and their request for relief. Once the petition is filed, the debtor becomes the debtor in possession, which means they maintain control of their assets while they reorganize their debt under Chapter 11. The debtor remains as such until there is a confirmed plan of reorganization, the case is dismissed or moved to another chapter, or a trustee is appointed. The debtor in possession is required to perform the duties of a trustee, which are accounting for property, evaluating claims, and filing the court-required information reports. Chapter 12 bankruptcy was designed for the family farmers and fishermen with a regular annual income. This kind of bankruptcy allows for the farmers and fishermen to pay all or part of their debts. The regular annual income is key for filing under Chapter 12, since this income is how the debtor will be making payments to pay off their debt. The repayment plan is structured typically around 3 years, unless the court sees fit to extend it to 5. Chapter 12 is beneficial for family farmers and fishermen because it is usually less complicated and less expensive than filing under Chapter 11, which is typically more suited for larger corporations. It is also beneficial for them to file under Chapter 12 as opposed to Chapter 13 because their debt tends to be higher than that of the normal worker. Filing under Chapter 12 is completely voluntary and can only be filed under by a debtor, not a creditor. Under Chapter 12, the debtor has 90 days to submit a repayment plan. If the plan is approved, the debtor will give the trustee the funds outlined in the plan, who in turn distributes the money to the creditors. If the plan is not approved, the debtor can either file a modified plan or convert the case to Chapter 7 and liquidate. Now I'll pass it on to Clay, who will talk about Chapter 13 bankruptcy.
Thanks, Julie. I'd like to start out by giving some background on Chapter 13 bankruptcy and then move on into who can use this method, the advantages of this method, how to file, and how debt is discharged under this chapter. The Chapter 13 bankruptcy is also known as the wage earners plan. It allows individuals that have regular income to create a plan to pay most, if not all, of their debts back into a 3 or 5 year period. The basis for whether a debtor will have a repayment plan for 3 to 5 years depends on if their current monthly income is either less or more than the current state median. If the income is lower than the state median, then the debtor will be subject to a 3-year plan. If the income is greater than the state median, the debtor will be subject to a 5-year plan. These are the only two options. You're probably wondering who's eligible for Chapter 13 bankruptcy. Any individual, even if they're self-employed or operating an unincorporated business, is eligible for Chapter 13 bankruptcy relief as long as their unsecured debts are less than $360,475 and secured debts are less than $1,081,400. Corporations and partnerships are not allowed to be to fall under this chapter of bankruptcy. An individual must also receive credit counseling within 180 days prior to filing bankruptcy from an approved credit counseling agency. Now let's move into the advantages of this chapter. The most significant advantage enabled by Chapter 13 bankruptcy offers debtors an opportunity to keep their homes from being foreclosed on. Another advantage of Chapter 13 is that it allows you to reschedule or postpone secured debts other than a mortgage for your primary residence and extend them over the life of the Chapter 13 plan. By doing this, you may in essence lower these payments. There's also a special provision afforded to debtors who choose Chapter 13 that protects any third parties that are liable with the debtor on consumer debts. This provision is basically aimed to protect any co-signers on loans. The third advantage is that no direct contact with creditors under this chapter. Instead, the payments are made to a Chapter 13 trustee who then turns around and distributes the appropriate payments to the creditors. Now let's talk about how to file for Chapter 13 bankruptcy. First, the individual must file a bankruptcy petition with the nearest bankruptcy court to the debtor's residence. The debtor must then file with the court a certain number of schedules. These include assets and liabilities, a schedule of current income and expenditures, a schedule of any contracts and unexpired leases, and a statement of overall financial affairs. The debtor must also sign a certificate that shows that they did in fact receive credit counseling from an approved credit counseling agency. In addition to these forms, the debtor must also provide the courts with a list of all creditors and their amounts and nature of their claims, the source, amount, and frequency of the debtor's income, a list of all the debtor's property, and a detailed list of the debtor's monthly living expenses. Now, the monthly living expenses should include food and clothing, shelter, utilities, taxes, transportation, and medicine. Now I'd like to talk about the discharging of debt in a Chapter 13 bankruptcy. When the debtor fulfills his obligation, then that is specified in the repayment plan, the debtor will then be discharged of debt. Remember that not all debts fall under the discharge. These debts that don't fall under the discharge are usually long-term obligations like a home mortgage, debts for alimony or child support, certain taxes, debts for government-funded or guaranteed educational loans, debts arising from death or personal injury caused by driving while intoxicated or under the influence of drugs, and criminal fines. One important thing to remember is that the debtor will still be responsible for these debts after the bankruptcy case has concluded. So after listening about Chapter 7, 12, and 13 bankruptcies, you may be wondering if you have any alternatives. Bankruptcy is often a last resort for an individual or business, but we want to make it clear that it's not the only remedy. There are alternatives to the formal bankruptcy process that may work for you and your business. One alternative is to seek credit counseling. A credit counseling service will help you to develop a repayment plan for your debts to creditors, much like that of Chapter 13 bankruptcy repayment plan. The only difference is that you don't actually have to file for bankruptcy. Another option for the debtor is to consolidate all outstanding debts into a single loan. This often occurs through what's called a credit card balance transfer. This approach relieves you of being tied down with debt from multiple creditors, since you will be making payments only to one lender. Like mentioned before, these are simply a few alternatives to bankruptcy and don't work for every debtor. Every case should be examined thoroughly to find the best possible outcome, whether that be one of the alternatives discussed or bankruptcy. Now I'd like to turn it back over to Amanda to talk about the pros and cons of bankruptcy.
So now that you've heard about the different types of bankruptcies for your small business, as well as alternative options, I would like to discuss some of the pros and cons for filing bankruptcy. Here are some of the pros. When you file for bankruptcy, it stops all collection actions by creditors, including foreclosures, repossessions, and garnishment of wages. Most states allow you to exempt your home, car, and other essentials, so you'll not wind up homeless or without a way to get around. Declaring bankruptcy now can also help you get started on building your credit and your life sooner rather than later. While nothing gets rid of student loan debt, at least bankruptcy will prevent your lenders from aggressive collection actions. It is also very important to remember that both judges and trustees have always heard worse stories than yours. Now, along with some of the pros for filing bankruptcy, here are some of the cons. You should know that you will lose all of your credit cards unless you pay them off before filing for bankruptcy. It will also be a long time before you're able to obtain any credit cards again. You also may have to give up some of your luxury possessions. A bankruptcy will stay on your credit for 10 years, making it difficult to acquire credit, buy a home, get life insurance, or even sometimes a job. Not all debts are discharged in bankruptcy. Student loan and back taxes for the last 3 years are prime examples of these. Remember, they do not go away. You'll also have to explain to your judge and your trustee how you got yourself into this financial situation. And remember, it can be very emotional. Our aim with this presentation is not to scare the budding entrepreneur away from starting a business or for fear of bankruptcy, but to simply arm you with the tools necessary if this were to happen to you. Remember, information is power, and knowing your options will prepare you to face these situations head on.